At this time, I'm going to call the meeting to order. So it is 6 o'clock, just for the record. And we'll start off with the pledge of allegiance. The flag that is I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, and justice for all. Next meeting, next item on the agenda is roll call to inform. So we have Christine May, then here. So we do have form. Next item is the approval of minutes from our January meeting. You guys have a chance to look at those. Dave, did you get a chance to look at the minutes from the January meeting?
Yes.
Okay. Do I have a motion to approve the minutes from the January meeting?
Make a motion to approve.
Dave Phillips makes a motion. Do I hear a second?
I'll second.
What's our group seconds? All in favor? Aye. Opposed? 4. Okay. All right, and now I'm gonna turn this over to council and just kind of go over the rules for this hearing.
Okay, so tonight we're doing a public hearing and just going to quickly review how the hearing is going to proceed tonight. First, I want to ask that everyone silence their cell phones. And I want to remind everyone that when someone is speaking at the podium, we're just going to have silence in the audience, please. So no booing, no audible signs of approval or disapproval. Please, let's be respectful. Anyone that's not respectful, we might have to remove. So the hearing is going to proceed in an orderly fashion, and it's going to go like this. So the chair is going to start the meeting and note the time. The chair is going to have staff frame the request and present staff opinion. The board can then ask questions. All speakers are going to take an oath here in a moment. Appellant, which tonight is Dolphin Solar, is going to present their case. Their presentation is limited to 15 minutes. The board may ask questions with no time limit on the board's questions. Then we're going to do public comments. We're going to have public comments against the appellant, Dolphin Solar, and then we're going to have comments for Dolphin Solar. They're going to be limited for each side to 30 minutes cumulatively, 3 minutes per person, 5 minutes for a group. Speakers should try to coordinate their presentations, so not to just repeat prior points. The chair may limit any redundant, immaterial, or irrelevant testimony at his discretion. The board may ask questions of any speaker with no time limit for the board's questions. Appellant will then be given 5 minutes to present the rebuttal presentation. The board at its sole discretion can extend any of the time limits. The board may ask questions of staff, the appellant, legal counsel, other board members, or any other speakers and clarification at any time. The board is going to then discuss the matter, and following the conclusion of any discussion and questioning, the chair will close the public meeting, note the time for the record, and no further testimony will be accepted at that point. The board will then discuss appropriate findings of fact and render its decision for the record. That's our general rules of proceeding for this evening.
All right. Thank you, Jennifer. So at this time, we are going to commence the hearing for the on the docket 2026-KP-001. And the time is officially 6:04 p.m. for the record. Okay. I would ask that all people who will be speaking tonight, if you would rise. we'll administer the oath. So.
Was it a plea vote?
Huh?
It reads right, a plea vote. Yes. Sworn.
Okay, so do you all, testify, or do you
Swear, test, or affirm.
swear and test or affirm under penalty of perjury that you will tell the truth? Then I say, I. Yeah, that was it. Right, so. This time, I'm gonna ask the, staff to present his opinion. His request.
Like you able to allow us to share screen?
Are you done request?
Do I need to get the IT guy?
Yeah.
You guys, we can share our screen.
Is working on.
Okay.
Board, I would like the time to start when his presentation starts, if that's okay.
He doesn't.
Okay.
I suggest someone that is gonna be putting a PowerPoint, if we can make sure that both of us are, all of us are able to do it. That's what the job. Yeah, so the new request. Shoot. Pushing it, but screen sharing says up to the 10, or you can attend screen sharing. Nice.
Right now.
Good evening. We got in touch, share it now. Good evening, my name is John Strike, I'm the zone administrator here in Patton County, Indiana. But again, talking about the pertinent evidence at hand, framing the question here. We'll be using the Patton County zoning ordinance. We have some external exhibits as well. The Dolphin permit application dated 10/2/23. The letter, email. Another email, we'll go through this quickly. These are our exhibits, seeking. Timeline of events, I'm gonna bring up a couple timeline of events. October 2nd, 2023, there was an application filed with Fountain County. By Dolphin Solar, they filed their CSDS application. Application deadline under the ordinance for determining whether application is complete, I want you to note is October 17th of 2023, you see 9.06. Of Fountain County zoning ordinance, that would be the deadline for that. There was a letter that was sent out by former zoning administrator, Roger Azar. He sent a letter. And he used the word completion on that. On, in October 24th, 2023, that letter did get sent out. On December 22nd, though, there was a letter that was sent for about technical comments that contradicts the completion of that. On December 19th. 2024, Dolphin Council emails about Azar admits that it needs to submit an updated site plan. December 27th of 2024, there was a conditional CSES permit noting that once all comments are addressed or resolved, a CSES permit will be issued. September 4th, 2025. Roger Azar states the Dolphin has not submitted anything regarding the technical condition on it. Nothing else has been submitted on them. September 20. Administrator, myself notified the conditional permit and dismissed the application pursuant to Fountain County Code. On October 17th of 2025, there was a Dolphin filed an appeal to the BZA. October 28th, 2025, Dolphin filed a lawsuit with Warren County Court. November 11th, county defendants filed a motion to dismiss on the grounds that Dolphin failed to exhaust administrative remedies by participating in the BZA hearing. It's premature on their part for that by bringing a suit when they had not exhausted their administrative remedies. County defendants filed a second motion to dismiss because Dolphin failed to file an agency record as required by Indiana state statute. Court issued an order denying the motions to dismiss, but stayed the case and said we need to put it back down to the BZA for that hearing, and agreed with the county defendants in that case. Why was Dolphin's permit nullified? That's the question here at hand, I believe, that we have to frame that question. Why was the permit nullified? What was happening here? When we go through the binders, and they're rather thick binders, I did not bring them for a matter of exhibit, but we're talking binders that are rather thick. Why was it nullified? Simply for non-compliance with the ordinance. Details matter. In football, it's like a game of inches. Maybe some of us are Indiana fans, and we like the fact that Coach Signetti was able to take a team that wasn't winning very much. Now they're the champions of college football because details matter. They also tell me in football that it's a game of inches because details matter. Rules matter. Dolphin exhibited non-compliance with the rules. Dolphin never had a permit. They never submitted all the required application materials in a timely manner. The ordinance does not provide for a conditional permit. There is nowhere in the ordinance of the Fountain County zoning ordinance that provides for a conditional permit. I guess I liken it unto being a Fountain County person. Maybe this is might resonate with some. It's like being halfway pregnant. There's no such thing. A conditional permit. 9.06 provides that if the applicant fails to provide the supplemental material for the application in a timely manner, the application will be dismissed. There are still pertinent facts, parts of the ordinance that have failed to be complied with. And we are nearly 2 years out when the permit was nullified. We're within days of that being 2 years. Relevant Fountain County ordinance requirements. It's not just Article 9. It's also Article 5.02. No permit shall be issued unless the proposed structure or use of structure or land is in complete conformity with the provisions of the ordinance. If you have things that are outstanding, you are not in complete conformity with the ordinance of Fountain County. 9.01, the regulation of solar energy systems, solar farms and facilities and other solar energy devices is designed to protect the public health, welfare and safety. Rules and details matter. 9.06, applicant must submit a conceptual site plan which includes 1, the general footprint of the CSES, the approximate number of panels, 3, the maximum generating capacity, 4, the general location of all fences, electrical poles and lines, the location of all other equipment and structures, 6, the general location of any and all underground electrical lines, facilities and structures, 7, the general location of all access roads and right of ways, 8, a general road use plan for construction, 9, general specifications for equipment, and 10, compliance with all applicable industry standards and safety codes and with the Federal Aviation Administration rules and regulations. I asked myself this question. I would consider, I think you should consider as the BZA, which of these is the most important? I don't know that there is a most important. I think all of these rules are very important. They are the zoning ordinances of Fountain County and details, rules matter. 9.06, if the application is not complete, the applicant must provide to the zoning administrator the supplemental information within 60 days. If the applicant fails to provide the supplemental material for the application in a timely manner, the application will be dismissed. It leaves the motion out of it. It leaves everything out of it. It is just an if then. I'm not a computer programmer, but it's a binary thing. It's zeros and ones. It is set in our Fountain County ordinance. They did not meet it, therefore it will be dismissed. The ordinance does not give a may, that gives into a motion, that gets into consideration. It says it will be. Steps in the CSCS permit process, you must enter an application. Within 15 days, 15, the zoning administrator will determine if the application is complete. The letter from former zoning administrator was after 15 days, and they will notify the applicant in writing of that determination. If complete, the application will be reviewed as a request for a CSCS permit. The application is not complete, there's a time period for you to be able to provide supplemental, and that time period is within 60 days. If it were to be deemed complete, the zoning administrator has 30 days to review the application for compliance with the ordinance and must issue a decision within 30 days from determining the application is complete. This was back in October of 2023. The application and the permit was dismissed and or nullified in 2025. We are well beyond the 30 days. Applicant may modify the plan. The applicant was given many chances to modify the plan. Once the application is approved, the zoning administrator shall issue a CSES permit. There's never been an approval because there's never been a CSES permit. There was a letter from December of 2024 has stated conditional, but there's no such thing in our ordinance. And it's also worthy of note, there's been no conditional permit ever issued, to my understanding, to any other applicant for any other thing inside of Fountain County on the former zoning administrator Azar told Dolphin his application was complete, he used that word. Ordinate at 22 days after it was submitted, the ordinance says it must be within 15. He later issued another letter on December 22nd, 2023, indicating a technical review had been completed and action was required and referenced the need to provide supplemental information within 60 days. So the original application wasn't really complete on 10th. The latest technical comments dated November 2024 note many unresolved deficiencies that were never addressed. Even council from or Dolphin themselves admits there was an deficiency in December of 2024. See example of Exhibit G. This is well past 60 days. The ordinance does not contemplate that conditional permit. There was a letter that was sent out, but it was very clear that once all the comments are addressed or resolved, a CSES permit would be issued. There has never been a CSES permit ever issued. There have been deficiencies that have been known since 2023. Known since 2023. To be issued a permit, the applicant needed to comply with the technical comments. Notice exhibits B, E, and F. But here are some things to demonstrate the application was never actually complete to begin with and was not properly supplemented as required by the ordinance within 60 days. In the deficiency, it says for me submit a fully executed and approved road use plan. We to this day still do not have one of those things that are supposed to be included in the application. Compliance with all applicable industry standards and safety codes. There was a letter that was tendered. With the technical comments noted a deficiency. We don't just need a letter, we need to have on file the copy of the documents that were reviewed, and it was a deficiency, therefore it was not complete. These are further deficiencies known since 2023 and further. The technical comments state the following items required by code are not clear. The general location of all electrical poles and lines. The general location of any and all underground electrical lines. This is out of the ordinance in order to submit an application. The application was not complete from the very beginning. Please address the deficiencies addressed of them. 9.04, again, details matter. 9.04 provides setback requirements, and in the comments from the previous zoning administrator, the application does not meet the intent of 9.04. These have been ordinance deficiencies, violations, if you will, in the deficiencies list. The application was not complete. And there was a letter that was written from Dolphin Council to the former zoning administrator in December of 2024. In this process, Dolphin Solar LLC identified one item that is required by Article 9 of the ordinance to be resolved for Fountain County to issue the permit. Again, the application was incomplete. Here's some lacking arguments that you might be able to argue. A legal entitlement to a CSES permit while trying to omit the word conditional. I've got one. I've got a CSES permit. You either have one or you don't. There's no consideration about a conditional permit. Failure to comply with the ordinance is somehow rectified by issuance of a conditional permit. Maybe we're telling him, hey, you might be barking up the right tree, if you will. But it's not a permit. The application was in. Limitless time to comply with the ordinance and technical comments. you don't have limitless time. Graciousness has been bestowed, more than 60 days have been given. Rules matter. Again, we find it seems like maybe rules don't matter as much to some as to others. The applicant filed a BZA appeal on October 17th and then just 11 days later filed a lawsuit. The applicant expected that the BZA appeal would be docketed at the October 21st, 2025 BZA meeting. But again, another rule that matters is that the ordinance says the public must be given notice at least 14 days prior to the public hearing. 21 minus 17 is 4. There is no legal way possible to hold a meeting, a legal meeting of the BZA on the 21st. Fountain County zoning administrator, I contend that the rules matter. These are important rules. Real world applications of why rules matter. The BZA, among other defendants, were sued. Why? Because the BZA did not hear its appeal just days after it was filed, which it could not legally do. Rules matter. The court even agreed with the Fountain County, but the lawsuit was premature and the court stayed the case until this hearing could be docketed. There was a request, or a failure to request, an extension, a one-page request for an extension of time to file the agency record when filing the record is required by state law. But it was never filed. It was never asked for. The agency record was never even asked for. Fountain County notified the interested parties pursuant to BZA rules. Interested parties are here today after receiving that. This evening, you will be hearing from a young lady named Lola, 10 years old, has pertinent information relevant to the appeal being heard today. Because rules matter. The BZA procedural rules state that they're interested parties and the public have a right to be able to be heard. Real world application. Indiana Code 36741001 states in part, when an appeal from the decision of an official or board has been filed with the Board of Zoning Appeals, proceedings and work on the premises affected shall be stayed unless the official or board certifies to the Board of Zoning Appeals that by reason of the facts stated in the certificate, a stay would cause imminent peril to life or property. In that case, proceedings or work may not be stayed except by a restraining order. There has been continued proceedings or work done in the footprint of the application that is being that was dismissed in September of 25. There was a BZA appeal filed and proceedings for work surveying is still happening. But no certification has been issued by the official to the Board of Zoning Appeals. Rules matter. To the point on information and belief on Friday, February the 13th, police or the sheriff were called because there was trespassing on property that does not even have a solar lease by these people that are proceeding with work when there's a BZA appeal. This is not the first time that there has been trespassing. My position. Dolphin never tendered a complete application. there was an untimely completion letter, and then it was reworded and corrected. He told Dolphin that they had 60 days, but they never completed the application. Pursuant to rules of Fountain County in September of 25, the permit was nullified and the application dismissed, as it says, not complete shall be dismissed. Nearly 2 years to remedy the decision. Not clear why there was a conditional permit. Because there's no such thing in the ordinance. But there was plenty of time for the applicant to address the deficiencies that are still outstanding. And there's no explanation for that failure, besides just stating, I've got a permit. We have that permit, we're entitled to that permit, but it's not a permit even given inside of the ordinance. Omitting the conditions attached to that letter, this dated December 27th. And the comments of the conditions of 9.06, those were not even satisfied. And they even admitted that there were deficiencies. From the 10/2 of 2023 application. Under the ordinance, you either have a permit or you don't. Dolphin, the applicant, never did. Thank you.
Board, yeah, we'll start with Dave, do you have any questions for? Thank you. Christine? When the, I guess when it was discovered that Alvin was not in side of what you were saying, that we had the conditions to have, the permit approved, what was your communication with them once you became something administrative?
There was no communication on that. I looked over the application. I had been, as the planning director and chair of the EDC, I've been looking over, many of the pieces of applications, not even dealing with commercial solar as they came in, communicating with the zoning administrator. I've been keeping abreast of those, on that, and, the application wasn't complete, so I think I
If
Sorry, what?
Actually, ask me to make sure you speak into the mic.
Oh, okay. Are you guys having difficulty hearing when he speaks? I am. It's a bit, speaks slow. Can we turn the mic up or is that something?
I don't think that amplifies. I would just speak loudly.
Okay, I'll try to speak up.
Do you guys have any other questions?
Obviously, you can ask them at the end too.
Oh, defer.
So you can call John back up later if you think of some.
Okay. Thank you. And this time now, how them up and. Do that.
Give us a second, we're trying to organize your testing.
And then just so you're aware, I have like a timer on here, so I'll keep track of the
Right.
time.
We spoke a little bit off the record, I've got this streamlined, so it should be near 15, so
Okay,
I'll do my best to keep it right at 15, shouldn't go over much. I'll let you know when I'm done. Are you ready?
timer.
All right, let's start. All right, thank you, Mr. Frog, Ms. Harder, Chairman Cunningham, and BZA. We're limited to 15 minutes or thereabouts, so I'm gonna keep the pace up. I apologize. Wanted to start with an executive. We'll pause for a second. I switched the slides. That's it. All right, there we go. Sorry about that. Wanted to start with a brief executive summary, try to encapsulate our position on kind of in one digestible format. So the nullification of Dolphin Solar's conditional CSES permit is unlawful. The county already determined the application was complete. The county already determined the 60-day rule only applies to the initial application. It does not apply to subsequent submittals. The county already issued the permit with conditions. The time to challenge those determinations has long come and gone. The county cannot arbitrarily change its position because current leadership wants to do things differently. Dolphin Solar submitted a completed application in late 2023. Fountain County determined the application was complete within 22 days. From this moment forward, Dolphin Solar had vested rights in its permit, is grandfathered in under the law in place at the time of application. This means the solar moratorium cannot apply to Dolphin Solar. This also means Fountain County can't revoke the permit just because it changes its mind. Dolphin Solar and Fountain County engaged in a 14-month technical review process with multiple rounds of technical back and forth. 5 volumes of information ultimately were delivered to the county. Fountain County issued a CES permit to Dolphin Solar in late 2024. Dolphin Solar relied on that permit heavily to its detriment, to the tune of $70 million in total investment to date. Political turnover in the county happens in early 2025. The attacks on the project begin. The county has been trying to find a basis, trying to land on a basis in the ordinance to revoke the permit. The letter revoking the permit says nothing, gives no reason for the revocation. We've heard some semblance of a reason tonight. Mr. Schrock spent some time talking about the 6-day rule, and unpack that in a lot of detail in the time I have. But when I listen to Mr. Schrock's explanation, essentially translates to the county has changed its mind. We don't like how the prior zoning administrator handled things, and now, after the project has relied, after we issued the permit, and after our determinations have become final, we're changing our position. The law does not allow this. Fountain County has no basis to rescind, revoke, nullify, or dismiss the permit. Fountain County is bound by its prior determinations. The revocation letter is unlawful and violates Dolphin Solar's vested rights. Dolphin Solar is suing Fountain County for injunctive relief of damages. The court has ordered the Fountain County BZA to hold this hearing. There is an injunction hearing scheduled in the Warren County Court for February 27th. At that hearing, we intend to ask the court for an injunction to stop the county's legal actions. And thereafter, we intend to pursue all damages sustained by the project as pursuant to the county's actions. Brief overview. We started with an executive summary. We're going to hit the housekeeping, introduction, and frame the issue. Move on to some project and permitting background. We're going to unpack Fountain County's unlawful attack on Dolphin Solar. We're going to end conclusion with the question of relief. Housekeeping. Sorry to keep the pace up. Sorry to do this so quickly. I'm Matt Newman. I'm from Denton. I'm a law firm based in Indianapolis. I'm with my colleagues, Megan Holler and Joe Capano. From the entry team, we have Lindsay Nelson and Solid Manning. Raise your hand. Say to shoot. From GNX, we have Wayne DeLong. And from our geotech Solon RRC, we have Edward Vasquez. I'd like to ask the record to reflect some continuing objections over BZA Rule of Procedure 1.12, governing a lack of impartiality with BZA Rule of Procedure 1.13, ex parte communications. We reserve our right to the extent there's a lack of impartiality for any board members tonight or any ex parte communications. We reserve the right to object to those and raise those objections later. Under Rule of Procedure 3.05, the chair should limit and exclude redundant, immaterial, and irrelevant testimonial exhibits. Brief summary of our critical exhibits is on the screen. The binders we submitted in the SharePoint site we submitted to their council includes an exhaustive list. I'm not going to read the entire list in front of you. Introduction, framing the issue. Why are we here? We're here to talk about one document. This letter from September 29, 2025. Why are we not here? This is not a special exception here. Community sentiment for or against Dolphin Solar is not relevant. So there is no place for public comment in this hearing. This is not a review of Dolphin's permit. This is not a hearing to weigh the pros and cons of Dolphin Solar. This is not a hearing to weigh the pros and cons of solar. The issue is very narrow. The only question is whether the report of dismissal, report of nullification is valid. On the screen, you have Dolphin's permit dated December 27, 2024. And this is the revocation letters dated September 29, 2025. 3 sentences outlined in the letter, all of the detail are on the screen. This letter purports to destroy, to nullify, to take back, to revoke this permit. Is this letter valid? No, this letter isn't valid. Project and permitting background. What is Dolphin Solar? Dolphin Solar is a 700 megawatt solar project that found county. Total anticipated investment once it's built is expected to be over $1 billion. The original developer is GNX Solar, sold to Engie. GNX and Engie are working together to continue developing Dolphin Solar. On-site construction has not started, but is anticipated to start in late 26, early 27. COD or commercial operation date, that's when the flip gets switched from the project. It's anticipated to be early 2029. Total investment to date is in excess of $70 million. Factual background and timeline. Given the time constraints, I'm not going to read all of these. We're going to walk through them in detail as I go through the rest of my deck. But these are the critical dates, many of which Mr. Schrock has already mentioned. Application was submitted October 2, 2023. This signed permit application is on the screen. It was deemed complete by the county 22 days later, October 24, 2023. I'll read this aloud. Please accept this letter as notification that your application for a CSES permit submitted to our offices in hard copy on 2 October 2023 and electronically on 9 October 2023 is considered complete. Important, from this moment, Dolphin Solar has vested rights protections. Under the law cited on the screen, Indiana Code 36741109, application provided gives rise to vested rights. Under the cases cited on your screen, state and local governments may not take action to infringe upon the vested rights of a permit applicant, particularly when the applicants relied upon the applicable laws and expended substantial resources in the development process. As a result, the solar moratorium does not and cannot apply to Dolphin Solar. At this point, the county and the project embarked on a 14-month technical review process. You heard Mr. Schrock said he didn't bother to take the binders detailed information here and put this in the record. This process is contemplated by Section 907. We've highlighted the relevant provisions. The applicant may be permitted to modify its CSES plan to satisfy any concerns with the zoning administrator. This 14-month technical review process includes multiple rounds of technical back and forth, request and response between the county and Dolphin Solar. In total, Dolphin Solar submitted 5 rounds of information, comprising in total 4 binders of technical information, supporting documents, multiple in-person meetings in Fountain County, voluminous emails and phone calls to resolve the kinds of questions in the process. This is a graphical representation of this technical review process that lasted 14 months. All the various in-person meetings, various binders, questions, phone calls, and emails. Exhibit 20 in your binder is a detailed summary outlining that 14-month technical process. Ultimately, the CSES permit with the conditions attached is issued December 27, 2024. No party appealed or challenged the issuance of the CSDS permit. No party appealed or challenged the discretion of delegated authority of the zoning administrator to impose pre-construction conditions with the permit. Dolphin Solar has invested in excess of $70 million in reliance on the permit process. Early 2025, political turnover happens. Fountain County begins to target Dolphin Solar, and searches for a basis to revoke the permit. To be clear, until tonight, Fountain County has never articulated a basis for revoking. Notice there's a shifting basis for revocation. The county is starting with the conclusion at once to revoke the permit, trying to justify its actions. Attempted political attack number one, weaponizing the 60-day rule. Fountain County zoning ordinance in effect at the time has to be understood to understand this attack. I've got the first page of the ordinance on the screen. If we double click on Article 9, addressing solar energy systems and facilities, that article is 4 pages. The attack rises particularly from section 906. Mr. Schrock cited to, I do have to point out, conveniently left out in our view, the most important language, which is if the application is not complete. If the application is not complete, the applicant must provide the zoning administrator with supplemental information within 60 days. We already know the county determined the application was complete on October 24, 2023. Your application is complete. We know the county and the permit and the project went on for a 14-month review process. The permit was ultimately issued December 27, 2024. It states very clearly, prior to constructing the CSDS, all technical comments provided to you and attached to this letter shall be resolved to the satisfaction. These are pre-construction conditions commonly imposed for permits like this. Prior zoning administrator, Mr. Azar, stood in this very room with a joint meeting of the commissioners and the county council. It's going just that. Spoke about the permit on March 3, 2025. He said, do they meet the requirements of our code or ordinance as it stands today? The answer is yes. Dolphin Solar met the requirements of the ordinance. So you cannot deny the permit because they met the requirements of the ordinance. He went on to describe those pre-construction conditions. That same day, he said, they just have to meet them, referring to conditions before they put shovels in the ground. There's no doubt in my mind that the rate these companies are spending money, they will meet the requirements. Attempted political attack number 2. We haven't heard a lot about it tonight, so we'll brief with the attack. But the issuance of this letter occurred around a time when there was an allocation project with the start of construction. Dolphin has not started construction. Dolphin Solar has not started on-site construction. Summer of 25, then she engaged RRC to perform routine geotechnical engineering studies, which are part of planning and design. Geotechnical engineering is the study of soil and rock properties necessary to design foundations, roads, and utilities. RRC is an engineering firm, it's not a construction firm, to be clear, and she has not signed the contract to build the project. It is not possible that on-site construction is started. Attempted political attack number 3. This one's recent. It's happened in the last few days, and that's an interference by the county with lawful routine pre-construction land survey. The permit was not given for surveying work. A permit is not needed to perform survey. Any landowner can perform a survey on private property. Consent will also maintain a statute that allows a survey to perform on landowners. Permit's not required. So any attempt by the county to interfere with that routine surveys is further attempt to interfere with the project. So back to this summary, we see attack number 1 is the 60-day rule, weaponizing the 60-day rule. Attack number 2, didn't hear a lot about tonight, but that's the start of construction. Attack number 3, interference with the survey. What next? Something new, hard to know. But again, I want to draw attention to the shifting basis for revocation. County started from the conclusion of wants to revoke the permit, trying to justify its actions. In conclusion, how much more than 2 minutes time down. Is this letter valid? No, this letter is invalid. There are enforcement provisions in the Fountain County ordinance. Those were ignored. The revocation is invalid. It's a blatant political attack on Dolphin Solar. The reason for the revocation is consistently involves, constantly involves to it. The CSDS permit authority to delegate with the zone administrator. County is bound by its prior determinations. The application is complete. The 60-day rule does not apply to subsequent submissions and ultimately the issuance of conditional CSCS. permit. The time to challenge these determinations has come and gone. The unilateral revocation with no stated basis for the revocation until tonight is arbitrary and capricious. Unilateral notification is not contemplated in the zoning ordinance. County cannot change its mind just because of a change in the condition. Res judicata, judicial estoppel, and equitable estoppel prevent the county from taking an inconsistent position to that which it has already taken. Fountain County has violated Dolphin Soul vested rights. Fountain County has caused irreparable harm to Dolphin Soul. There was an injunction hearing on February 27th. Dolphin Soul was pursuing injunctive relief. Stop applies illegal actions thereafter. Dolphin Soul will pursue all damages caused. Zoning administrative decision was wrongful, willingness, arbitrary, and capricious, and use of discretion. Our request for relief is to reverse and overturn the September 29, 2025 decision with zoning administrative revoking Dolphin Services. Then my presentation. Thank you all. Thank you.
Questions from the board, start? Dave?
Me, when I read that, the word conditional means a conditional permit, 60-day timeframe. Seems like me to be in effect, so I guess that's my question. Why is the word conditional going to be in it?
I did my best to explain it. I didn't write the permit, but in my experience, attaching pre-construction conditions like this are very common for a permit like this. Whether it's an exception, whether it's a conditional use, whether it's an ILP. And I'm reading from this. In addition, prior to constructing the CES, all technical comments provided to you on November 8th by the office engineer attached to this letter shall be resolved. So it's a permit. And because construction is not starting imminently, those have to be resolved. Roger A. stood in this room testifying that was the intent of those conditions. But you would expect them to be resolved. That's the purpose of it.
Can you speak up?
Okay.
You start speaking very soft,
Okay.
and we can't hear.
Sure.
Okay.
Do you have any other questions, Dave?
No, this is slow.
Haven't?
The part that the Dolphin did agree on that was still lacking the site, why was that never submitted?
My understanding is it was. The permit was issued days later after that letter.
No, the site plan was still outstanding, and has never been given to Rogers.
Do you have that information to submit to us? If it's they completed, where is it at?
That was something that Dolphin also agreed that it was lacking that we provided. I think Rogers said that it had not received that yet. Today.
But again, it was a pre-construction.
That's a site plan that's in ordinance. And I don't know if I'm using the right words, I don't have what he's got there, but I'm just questioning why wasn't that admitted? That you also said was outstanding.
Council, I was not sworn in.
Okay, thank you.
And, you swear under penalty of perjury that you will testify truthfully?
I do. Thank you, Wayne DeWong, Jan, speaking for Dolphin School. Well, it should be one of your exhibits. There was a letter mailed to Ms. Colleen Chambers on December 24th, which contained site plan to which you're referencing this evening. Colleen, Ms. Chambers, should have inserted that site plan into the file. The letter that was mailed to Colleen with tracking indicated that information. The site plan, that same site plan on December 22nd, I believe was shared with Roger. But yeah, the permit file does
Yeah.
share that information,
He's
yes.
living here site thing. Yeah, so are we lacking that in, was it never entered?
Then also on this email from Roger. He essentially says that none of that has been submitted from you guys, so we don't have any.
That was his, what he had not received that.
That was actually to you, so.
What? Can I see that? Can I see what you're referring to?
It was in John's presentation.
The letter from Roger.
Can you hold on for just a second? I'm told that the fans are maybe making it so that people can't hear. So let's turn the fans down. And everyone, please try to speak loudly. I don't think we have good mics in here.
This, the letter does not accurately characterize the very thing that just stated to you under oath. That on December 22nd, that site plan was provided for Roger. There is a letter that was mailed with tracking to the Appellant chambers. You should find video evidence in early 2025 where Colleen speaks about receiving that letter, but acknowledges not yet filing it. It's still within the stack of papers in the back of her brain. I don't know the date of that video, but I would offer that that statement was made. So we have tracking that indicates the site plan was mailed. We have acknowledgement on video that the site plan mailing was received. The email communication indicating that it was transmitted. I'm unclear what Mr. Azar is saying to you in this letter.
In addition, I think it's worthwhile to clarify, as I read this exchange between Mr. Strzok and Mr. Azar. Have they completed any of the listed items referring to the 20-page technically new document from December? And Roger Azar separately said those were intended to be pre-construction conditions, so to ask that have they been completed by September of 2025 doesn't match what Roger's already said, which is their pre-construction. So there's no deadline.
I guess I'm not, what he was calling pre-construction tasks, requirements is not the general site plan. That is still just asked for in the ordinance. And do we have this in our documents? I don't see where they have tendered that. What I reviewed was Roger said they had, yeah, that was the latest communication.
So what's being passed to Ms. May here is a photograph of the mailing. So, I mean, you can see that the mailing was placed in a large paper craft style envelope with tracking. There should be again, we have on video acknowledgement of receipt of that and discussion of the receipt of that. At least 3 copies of the site plan were placed in the file because I mailed it. So I can speak to that on the record here.
So is there, where is the letter from Roger stating that that was received? Am I missing that?
I don't believe we received verbal recognition of receipt of every piece of paper. He did issue the permit a few days later. We took that as acknowledgement that he received the site plan, reviewed it appropriately, and came to the conclusion after discussing it with Mr. Aaron Fields on the phone about the issuance of the permit that's being discussed.
So you submitted this December 24, but December 25 is when we effectively retroactively, whatever was passed, gave you the permit,
December 27th, it was
but it was
transferred.
2025, not 24.
2024.
It's a lot to juggle and shuffle with
Understood.
all of the Rogers letters back. That was my main question, that the site plan that he was waiting for, it was my understanding that he was still waiting for it and hadn't received it. So that's I don't know if I haven't seen, I've read through all this several times this week. That's my question, I'll yield now, but I'm just gonna take it and see.
Any other questions, Christine?
Which something do you want this back? I don't know, just try to keep it organized.
No, I'm trying to see. What process that?
Ruben, do you have any questions?
I guess I would go with what David said as far as the conditional permit. There's nothing in our ordinance as far as that goes.
Yeah, you kind of keep referring to it as the permit, but it clearly states it was a conditional permit, but those things were cleared up within 60 days. So we're kind of reading two different things here, or interpreting it as two different things.
Irvin, did you have any questions? You don't have to ask him right now, we can call him back up if you want to roll it over a little bit.
Yeah.
Yes, I guess I'm related to the site plan that you guys submitted. This is like what, December 2024? Is that right? Okay. And then, letter from. Letter from Roger, it says that, it's technical review, please note that per Article 9, Section 906 of the Fountain County Code, if the application is not complete, the applicant must provide the zoning administrative the supplemental information within 60 days. If the applicant fails to provide the supplemental material for the applicant in a timely manner, the application will be dismissed. To me, it seems like 60 days was the timeline they gave, and this is dated December 2023, so that would be outside of the 60-day period, correct?
But the process then continued on, so I mean, I would agree with that, but it's clear that then our technical review process carried on for another 10 months or so after that. I don't think it looked at the initial program.
That's where I'm questioning. It's not a technical requirement, it's an ordinance requirement, and it was outside of the 60 days. It still is outside of. It's not a technical requirement, it's in 9.0, 9.6. That 9.06, that site plan is outside the 60 days, even if it wasn't. Like I said, I'm conflating a lot.
You guys can
here.
have a discussion, but right now, let's try to just ask council questions he can answer.
Okay. That's.
Guys, any other questions for?
No, that's.
That's all I had to say. Thank you.
Thank you.
Okay, so now we're gonna do the public comment, and I have the sign-in list. Just one little point of clarification. We had a sign-in sheet and then we had speaker forms that everyone was to fill out indicating whether they wanted to speak in favor of Appellant Dolphin Solar or whether they wanted to speak in favor of the zoning administrator. And I think everyone but one person signed up to speak for the zoning administrator, but one person indicated that they wish to speak for Dolphin Solar. And I want to just make sure that that is correct. Do we have any other? We just have one Dolphin Solar speaker and everyone else is here to speak for the zoning administrator. Is that correct? Okay, we're going to do the comments for the zoning administrator first, and we're just gonna take them in the order of the sign-in sheet. We're gonna try to limit comments to 3 minutes because we have just over 10 speakers, so hopefully you don't have to use your whole 3 minutes, right? If you have a 30-second comment, that's just fine. But we are gonna try to limit it to 3 minutes just so we can keep things moving. So I'm just gonna call the names, and I'm sorry if I can't read handwriting, but our first speaker is Larry Schropp.
My comment is in regards to the 60 days also, and that is, that seemed like a huge. One of those tiny rules by inches. As referred to, and in football. And it matters, so I believe that is kind of apropos to your questions that we were having with us. Thank you.
Okay, next we have Cheryl Fletcher.
My family's coming with me, we each have a short statement, if that's okay.
Okay. So you guys will be a group then, and,
Technically, yes.
okay,
We'll start with my mother. Well, I'm very nervous about this too.
it's okay, take your time.
Hold the mic down before her.
Oh, does it work? I don't know if
Kind
it
of.
works or not. Okay, my name is Janice Surrey, and I married to Russell Surrey, who passed away a few years ago. I still live on our family farm and have lived there for 61 years. The Dolphin Solar Project directly affects me. I do not believe that the solar panels will do any good for any of the farms of Fountain County. I'd like to tell you about an incident that happened on my property on September 1st, 2025. It was on Labor Day. I was driving down the road and saw trucks with large poles trespassing in my bean field. I stopped and asked what they were doing in my field. They said that they had permission to work there. I told them that I am the owner and I do not give you any permission. I told them to get off of my land now. They had driven their trucks into my bean field and ruined some of the crops. Afterwards, I went home, called the farmer who farms for me, and he came out and talked to them. Following that incident, a lawsuit was filed for trespassing and damages. This company obviously did not care about my property rights and the boundaries for land outside of the project. This large solar panel project is not good for the people who have spent their life savings on a place to live in the country, and they will only be surrounded by solar panels for the rest of their lives. The beauty of the countryside will be gone forever. Thank you.
My name is Cheryl Fletcher, and I am a fourth generation farmer in Davis Township in this county. My mother, Mrs. Russell Surrey, owns the adjacent farm. I would like to formally petition that the project by Dolphin Solar cease and desist immediately due to bad business practices. Please reject any zoning application now and in the future for Dolphin Project. My family has been there for 4 generations. We believe in being good neighbors. This means cooperation between farms and not hurting the others around you. Unfortunately, the cooperation between farms is being put in jeopardy, specifically regarding water drainage and the interconnecting tile systems. What happens when construction damages interconnecting tiles and floods neighboring fields like ours? This project has pitted neighbor against neighbor, and no study or fancy presentation can negate that fact. Last fall, Dolphin Solar contractors were caught trespassing on my mother's bean field. There was damages, there was a lawsuit. That damage to the crops was part of that process that they were constructing. They brought trucks with constructing equipment into my mother's bean field for an adjacent field in the project. There were unauthorized drones flying over our properties, drones that were flying illegally over our privately owned property. Earlier today, I spoke with Mrs. Teddy Stafford, a lifelong resident living smack dab in the middle of the construction zone. She told me that the solar contractors were caught trespassing on her land as recently as Friday. Mrs. Stafford filed trespassing charges only 4 days ago. Not participating in this project did not stop Dolphin Solar contractors from trespassing on her land or ours. Dolphin Solar total disrespect for the boundaries and property rights have been very disturbing. This is not good business practice by any stretch of the imagination. If allowed to proceed, this solar project will forever slash the number of available farmers that we have that can produce grain for us. Farmers currently maintaining equipment and storage will no longer have need of their assets and will quite literally go out of business. What will that mean for the small family farms left that did not sign on that dotted line? Will our ag economy collapse? How can this not detract and ultimately destroy property values and home values in the whole area? Please do not allow this project application to be approved. And thank you for your attention in this matter. It is probably the most important decision Fountain County will make for generations to come.
Yes, my name's Terry Serene, that's my mom Janice, and I'm a stickler for rules. And if you're 1 second late on your permit, you're late, there's no ifs, ands, or buts about it. And I strongly feel too, that, taking prime farmland and turning it into solar farms is not going to be helping our nation's food supply. We'll be depending on other countries for our food, and we've done this for a long time. Thank you.
Do we stay for questions or no?
I don't know if there was any questions, but you're fine.
Sorry.
Yeah.
I didn't know that. You need to stand for us.
All right, next we have Gerald Hutz.
Well, I did raise and Jones, you're in Hutch, Matt, Indiana, that's been my whole life, lived in Fountain County. From what I've heard so far, it sounds like a lot of things look done. And as long as I've been alive, if you don't do everything you're supposed to do, you don't get what you want. And it really, really kicks me in the head to hear someone say that anybody in this room is ill. But I know a lot of these people, as far as I'm concerned, they're all done. And, you know, I own a piece of ground out there. I knew what was going on. But the only time I was notified anything was actually happening, was when I got that certified letter in the mail a few days later. I thought, okay, I need to go see what's going on, because, you know, I'm a small fish in this big pond. But I got the piece of property I have. I like to go out there and sometimes watch the sunrise, and someday I like to develop it. But if this happens, I won't even be able to sell it. God bless everybody, take care. Thank you.
Okay, next we have. Clint. What is it? Kilby.
Oh, that's been repetitive, make sure that.
Thank you, I live down Gregory Road. I heard you say you have a permit, and they say they don't. If you have the permit, where's that? We have to have a building permit. We don't have a provisional permit to build a house or anything, so why can you build without a permit?
Sir, if you could direct your comments.
Okay, I'm sorry.
Yeah.
Can they build without a permit? And then I was also told that they're driving pilings up there the day that they fired the last ordinance administrator, which they say they're not working up there, but obviously they are. We get fined for that, I think. Do they not get fined for that? That's all I got to say. I think most of the people in here are against all this mess, ain't shit. I mean, is that pretty much a raise of hands? That's all I got to say.
Okay, Patrick Smith.
He's there.
I'm Patrick Smith. I worked on Promora Solar Farm. It's a real big benefit. I know they talk about the eyesores and all that, but the electricity.
Oh, sir, are you gonna speak on behalf of Soul,
Yes,
Dalton?
yes.
Okay, their time is gonna be next, so I'm gonna move you to the other list. Right now, we're speaking on behalf of the zoning administrator. So I'm just gonna put yours in the other pile,
Yes, ma'am.
and you can come back and have your 3 minutes. Okay. Next is Norman Allen.
Yeah, I just want to say that.
Yeah, I'm totally against this thing, totally against it. I live outside of Attic on Bethel Road, where it affects me more because they are planting this stuff in our fields right behind my house. I don't want to look out my window and see solar panels. I don't want to look out my window and see buildings. That's why I don't live in town. I've lived in the country almost my entire life. For the main reason that I like the peacefulness and the quietness. And I don't want that to change. It's a nice community out there. And there's a lot of houses affected in that area. It's not just mine, there's like 6 or 7 of us right in that one little area. They put these solar panels in. It's, what's that gonna do to my property value? You know, my tax is already high enough the way it is. And what's this gonna do? It's just, it's nonsense. And I believe he said that this wasn't the time or place for a public speaking. But I'm telling you, this is my county. This is our county.
Please
It's not
address,
your county.
please address the chair.
Huh?
Please address me with the talk.
I'm sorry.
Chair, it's fine.
Oh, guys. But this is our county, it's not theirs. I don't know where they're from, I don't care. But all I know is they just come in here for the money. They don't care about us. But that's my saying.
Okay, next we have Joanna and Lola, and can you pronounce your last name for me? Sites, okay, are you gonna go together or separately?
We have 2 separate things to say,
Okay,
so.
Joanna, you can go first.
Good evening, my name is Joanna Seitz. I was raised here and I am still a resident of Fountain County. I am here tonight to express my concerns and explain the reasons that I object to the Dolphin Solar Project. I'm raising 6 children in the home where I grew up in and on the land that has been in my family for generations. My primary concern related to the Dolphin Solar Project is the impact it could have on the health and safety of my daughter. She is profoundly deaf. She relies on bilateral cochlear implants to hear. These implants are medically necessary and they are electronic devices. They function through internal components, magnets, and radio frequency communication between the internal and external processors. She had surgery as an 8-month-old baby so that she could hear. Federal regulators and manufacturers both acknowledge that implanted electronic devices can be susceptible to electromagnetic interference, particularly around high voltage equipment and electrical infrastructure. The proposed project is just down from my house. It is not simply a field of panels. It includes inverters, transformers, collection lines, and transmission equipment that generate electromagnetic fields as part of their normal operation. There are no long-term studies available that evaluate the safety of large-scale solar facilities in close residential proximity to children who rely on cochlear implants. There is no site-specific testing. There are no guarantees. Believe me when I say, I have researched and researched to try to find some sort of assurance that this project would not cause harm to my daughter. Even the Dolphin Solar representatives have not been able to assure me that interference is impossible. I asked directly to the representatives, can you guarantee they will not interfere? And they could not guarantee it. For my daughter, even intermittent interference could reduce her ability to detect approaching vehicles, emergency warnings, someone calling out to her. Her access to sound is directly tied to her safety. When uncertainty exists regarding potential interference with necessary devices, especially in a child, caution should prevail. I ask you to consider the high cost that this project could be for my daughter. In my opinion, the stakes are just too high. Beyond the medical concerns, this project would fundamentally change the character of our rural residential area. The scale and industrial nature of the infrastructure is incompatible with the established homes that have existed here for generations. I respectfully request that you deny Dolphin Solar's appeal and prioritize the health, safety and welfare of the families who live here. Thank you. Lola wants to say something as well.
Go ahead, Lola.
Hi, my name is Lola Sess. I'm 10 years old. I was born deaf and I use cochlear implants to hear. Without my implants, I cannot hear voices or cars or warnings. They are how I stay safe every day. When they are off or not working, I cannot hear anything at all. If something ever breaks, my mom makes sure we have backups ready because I cannot go without being able to hear. My implants have given me the gift of sound, something most people don't even have to think about. They are how I stand here and talk to you today. They are how I hear my teachers, my family, and my friends. I have worked very hard since I was a baby to learn how to listen and speak. It hasn't been easy, but it is very important to me. If my implants stopped working, I wouldn't know what to do. If something caused them to mess up or not work, I'd feel scared and upset. Some of my favorite things to do are playing basketball and softball, playing in the creek by my house, and building forts in the woods. My brother and I have been building a big teepee this winter. It feels like our own secret clubhouse. I don't know what could happen if there's an interference from the solar equipment. If it gets built near my home. Not knowing makes me nervous. I just want to be able to hear safely at my house, and when I'm outside today, I cannot. Thank you for listening to me.
Next up is Dane Maltzberger.
He had to go to work. Is it okay if I speak in his stead?
Did he sign a proxy or something so you could speak in his place or?
No.
And I think we're gonna have to go to the next person. Tyrone Gutierrez.
Tyrone Gutierrez and I live in Fountain County and I would be surrounded on all four sides in close proximity. The reason I believe I'm here to support Fountain County in their denial of the field. And the reason I think that this needs to be denied is because the permit is tied to active litigation. It's going to weaken the Fountain County's future zoning power. So if you deny it now, it's gonna, obviously we're gonna go through the courts. Cautious approach is probably the best in denial of this appeal. Thank you.
Okay, now we're going to hear for folks who are here to speak on behalf of Dolphin Solar. We'll call back Patrick Smith.
Patrick,
Hello.
I think it's a good thing. I'm not thinking about what it looks like for the generation right now, this for the generations coming. Like when Texas had that winter storm, they ain't getting no power. Once they set this grid system up, they can shoot it down there where my kids, my grandkids are. We all can't grow roots right here and stay here. I was born and raised here. My grandfather was a farmer, dad was a farmer. But we're growing, we're evolving. We don't want to stay in one spot, That's how I felt when the Family Dollar moved in beside me. I knew what the Family Dollar coming. And once it did, it was good. It brought jobs. For Morris, when I worked there, it brought me from poverty up to thriving. I was able to send my kids money, grandkids money, paid off credit cards, start paying my house off. So I just say it's a good thing. Any questions? All right, thanks.
Okay, and our final speaker, I believe, for this evening is John Randall.
Good evening to the Fountain County Board of Zoning and to everyone here today. My name is John Randall. I'm here to advocate on behalf of the family's farm located on 2263 East Bethel Road. I want to speak on the benefits of solar development and the caution of the board are regarding the wide implications of denying the zoning request. My opinion, the opposition we see today isn't truly about permitting issues, it's about third parties attempting to dictate what we are not allowed to do with our own land. I emphasize with the hesitancy towards change. You can drive from north to south in the state and see no solar signs in every other yard. There's an understandable concern in our agricultural community about seeing farmland followed, especially at this scale. However, it is our right as property owners in accordance with the Indiana state and local law to use our land as we see fit. We live in Indiana, a state that prides itself on personal liberty and property rights. We should not be looking to mirror states where government dictates your daily life and business decisions. It's becoming more difficult each year to farm without government overreach. Since last year, seed prices have increased 5 to 7%, and fertilizer costs have jumped nearly $27 an acre. Input costs have risen almost every year, while sale prices of our yields have failed to keep pace. When you add in the right to repair hurdles from equipment manufacturers, it's becoming nearly impossible to farm without relying on federal bailouts. My family does not want to rely on incompetent federal government to make up the difference for a bad yield or low market prices. We want to take the initiative to diversify our revenue streams. This solar project is the tool to ensure our land stays in our family for generations to come. The reality is, the power demand is surging in Indiana across the globe. While different groups predict varying levels of growth, the consensus is clear. U.S. power consumption is on track to outpace current and improved production. We are already feeling this. Indiana residents recently saw some of the highest rate hikes in the nation as our aging infrastructure struggles to meet demand. We need local, reliable energy. My family is ready to help provide it. To finish off my time, I think the statement, a grand jury can indict a ham sandwich, reigns as true as bureaucracy is the enemy of progress. The permit was approved a year prior and is being rescinded without any true attempt to mediate. This action only signals to anyone looking to invest in this great state that Fountain County is not the place to do it. Thank you for your time.
I was gonna, we do a short break.
Yes.
Yeah, that's fine.
We're gonna just take a, how do you think, 10-minute, 5-minute? Let's do a 7-minute break. Very early, and we'll stop the hearing at 7:28 and reconvene at 7:35. Making sure I'm not gonna knock something important. I'm sorry.
If he's gonna keep it, he was bringing. All right. So we'll get in touch with him and send you what you get, so you can compare it to what.
Yeah.
I was Yeah, he left, he didn't find it, so that's my, I'll give it to you. I know, I think you were still on there.
No, that's all right, yeah, thank you.
Very well.
He has the signed promise of Josh that has his. Okay. Close, he said. We don't have to stop. Make sure we have.
Hard to read out.
Okay, all right, we're going to resume the hearing. It is 7:37 for the record. And now I'll give you a chance to rebut.
I think we'll be super quick. I'm not even sure we're gonna use our 5 minutes. So there's one clarification, the project has not started construction. The permit that has been issued has conditions which are to, prior to the start of construction must be set. Construction has not started. There was reference to some pile work. I'm gonna quickly explain as an attorney, layman, not a geotech, and as our geotech consultant. That was pre-constructions work to inform the design and layout project. It was not construction. There were test piles driven. So that is where a pile is driven into the ground. Assumes some sort of studies to understand whether, piles that are actually driven for construction, how that's going to impact the ground and if it's an appropriate design. And so there were test piles, that's not construction. They were then removed, and that's to inform the design of the project. And then has anything to add, I'll ask you to come up with everything add.
You nailed it.
All right, well, I'm not a geotech consultant, but if you don't have anything to add, that's the only
Nice to have a question.
clarification we made. Thank you.
So now this is a chance where you have the opportunity to bring up anybody who's spoken tonight to ask any further questions if we have any. Maybe you have any other,
No, don't go to
okay? Steve? You're good?
I don't think I do.
Thank you. Right. Does anyone have any questions you want to ask of the parties before we close the hearing?
I mean, have we seen an actual final permit? I mean, is it just the one from December? Is that all that we have?
I guess who are you asking that question of?
To Dolphin, as far as have you received? Is it just the December 27th? That's the only, that's all you have? Correct. And it would be conditional.
I think it's worth clarifying, it's a permit with the conditions. Conditions needs to apply what they have before the start of the job.
Right.
So it's not a conditional permit, not satisfy these conditions for how. It's, you have a permit, if you, once you've satisfied these conditions. Right.
Well, I'm just curious because even on your own, it said they just have to meet them before they put shovels in the ground. There's no doubt in my mind at the rate these companies are spending money that they will meet the requirements. That was from March 3rd, so that would be a question of myself. What was actually,
Would you mind speaking at the mic just so we can have the report? I'm sorry.
Yeah, what's the question, that's a statement from Roger Ailes, right?
correct?
What's the question?
Again, it would be if it was clear in Roger's mind that he issued a permit, why would he have said these things?
If. I believe his prior statement was he did issue a permit, did because the permit complied with the ordinance. And we went on to explain that there were conditions which were pre-construction conditions and conditions that needed to be closed out before it started construction. And the permit refers to, before you start construction, see me to make sure these are closed out, you'll have a meeting and you start construction.
Does anyone else have any questions
And,
for him, but while he's up there?
and just to clarify, the project is not started construction. I hope you made that clear. We can clarify that.
I don't. You guys,
No, but I'd like that discussion. Do we,
well,
will we be
we
able
have
to
to get through
still
all the
have
people first.
a question? Will we be able to ask questions after?
No, we're gonna ask our questions now, and then we're gonna close the hearing, and no more further testimony is gonna be taken, and you all will deliberate at that point and render a decision.
I think time, you know, we. I think there's something that you can do.
Right, get it right, ask the
Yeah, talk to
questions.
somebody.
it's not a question, but it's. I can frame this question. Where did Roger, that's what I don't see in here, and I don't know if you can direct me to it, where he acknowledged.
You ask me questions too. You asking me where something is, or you asking him?
Where he acknowledged receipt of still the one outstanding thing of the ordinance, not the technical requirements and all the extra stuff. The very basic ordinance that they admitted they still needed to, and Colleen supposedly got, I don't see that, and so I don't know where to look.
If you look at it, Dolphin Exhibit 20. On page 21.
In the white binder or the
It's
side.
in Dolphins exhibits, I believe it's exhibit 20
You have that analysis.
at page 21. Your Colleen encloses an updated version of the site plan on file with permit application and supporting documents. The same has been provided to Roger Azar electronically. For reference and record purposes, please place enclosed copy in the permit file maintained by Fountain County. That was sent in on December 24th, 2024.
I'm certainly happy to speak to the question you might have on that. I think the key word there is additional, or whatever the word was, to indicate the project had filed at the initial date, a site plan. The site plan was part of that complete application. As the project moved through the review of the tech committee and Roger's comments, there were subsequent versions of the site plan that were submitted that answered very specific questions. In this very last iteration of the site plan, specifically, Roger was focused on setback. The site plan was adjusted 30 feet. And that site plan was submitted to Roger as spoken to. It was mailed to permit file. Permit file is maintained by the county, so the public can see what is on file at any given time when the building is open. And the letter should speak volumes about how that was transpired.
Thanks.
Any other questions? Okay, thank you.
We don't actually have the words from the launcher, because even in the December 24 condition. We can't see that Roger said these deficiencies that are directly to the ordinance, not the technical building requirements. The last thing we had was from a few months ago, March of 24.
The court reporter's having a hard time hearing. I think what you're asking is how to interpret the grid that you're looking at.
Yes, because.
And that's one of the things we're gonna have to decide tonight is what was required versus what was tendered, right? And you're gonna, there's two different versions of events here, one by Dolphin and one by the zoning administrator, and you're gonna have to weigh them out and decide which one is more persuasive based on the evidence in the ordinance, right? That's your task tonight. Heard both sides about the import of the permit and its meaning, whether there was a permit or not, and you've heard evidence about the 60 days and whether that matters. You're gonna have to make those decisions and that's for you all to decide. I mean, to some extent, I can jump in, but. I think we can close it.
Is there any other questions for anybody? So, okay. So at this time, we'll close the hearing for public comment and speaking. It's 7:58 for the record. So. Okay, we're ready.
So is this our discussion?
Yes, this is our discussion. Yep, so right now, we can't ask any questions, this is just.
My whole point I'm trying to make here is, say for instance, if me or anybody in this room went to a bank to get a loan and they put some conditions on that application, getting a loan, and you had 60 days to comply with them. If you didn't do it, you're not gonna get the loan. And that's the way I'm treating this, as it was kind of a rules that they had to follow to be able to get a permit, and it was just a conditional permit. So that's the way I'm looking at this right at the moment.
I think it was in a good faith. You know, like, hey, we need to get this done, but it never just happened, and within the 60 days, or even to this day, do we have all the information needed, 2 years later? I think that would be the question for myself.
Yeah.
I'm concerned about, it doesn't matter what this project is, I know there's great importance and lots of money invested. But as a BZA in the future, we have to have the same letter of the law. And I am concerned about the term conditional, it exceeds his authority to say conditional, period. And then there was the deadlines not met, and it is a huge project. There's a lot of moving parts, it's nothing, I appreciate that. But as a BZA, we'll still be here next month, and if a development comes, if there's something that's just legal, if it's just out of the law, that precedent is set. Then how can you really, where really, like, I know Roger spoke his opinion that, well, I'm sure they'll do it because there's a lot of money, it's like, well, we have nothing to hold it to that, and so any, or not them, a project, any. To the BZA, we have to, I think the conditional permit bothers me, and Roger has underscored it and bold and then, and I think he was screaming loudly, this is not a permit, because he says, when you do these things, then I'll give you a permit, so this could be. If they're starting construction in 26, late 26, so then. ZA has to issue a real permit, because that is exactly what that December letter says. Then they'll get a permit. It's still is saying conditional until those technical requirements are met, the shovel ready type. All of the studies that still need to be shown.
Yes, that's a piece. Is there another document on here that talks about issuing another permit? This, the one from conditional permit email says, you know, this letter serves as a conditional permit. It says, gives the, you know, type of comments and all that. This failure to do so will result in nullifying this conditional permit. Is there anything that states that there is another?
Yes, ma'am.
No, that's what I mean, since he's no longer zoning, I think it's now would be John that would issue that.
Okay, okay,
CSCS. Perfect.
okay, you're right. So what's this? And this is,
That was-
this is dated December
Basically, that
2024.
was, I assume this was sent with
That's the enclosure.
that same at the same time.
Okay.
And that was.
And it does say, once all comments are addressed or resolved, a final CES permit will be issued,
So.
implying that there is.
There's still no real permit issue. And that's in the December time.
And it does say, in addition, prior to constructing the CES, all technical comments provided to you on November 8th by the Office of County Engineer and attached to this letter shall be resolved to the satisfaction of the county. And just like there's some wording on there that says timely manner, I think satisfaction of the county is something that can be interpreted, you know, based off of, you know, whoever.
The old
Where was
permit
that?
that was
That way.
issued was the conditional one. I don't see anything that there was an actual permit.
Well, and if that's the case, if. That is the case as a BZA. Then also that means that there are no vested rights because there was not a permit issued. In Indiana code, there's not even a basis yet for vested rights. So it just hinges on, I think, from the conditional permit language. And future, just setting the precedent, and I'm knowing this is a huge project. And I don't think the zoning authority, they don't have the authority to change the ordinance and say that. Somebody, can you advise us with that even? Just understanding that as a BCA, you know, that it just calls for something that's not there, it's yes or no, and wait. You know. That's how we've treated other cases that have come up. They've come back, it's like, no, you still need these requirements, to come back in the ordinance, and you have to come back. That's how we've just treated the short term I've been on the BCA. Just because. We feel a lot.
Well, I mean. So. Saying that. There is a conditional permit, and then once all the comments says there's addressed the result, a final permit will be issued. To me, that seems more like transitory. And so. It does not sound to me like it's a revocation, just more like what they're saying in here, as Roger said, nullifying. Resolve the satisfaction of the county. That can be, interpreted in many ways, and since there have been several attempts on behalf of Dolphin too, because they said they had a lot of meetings they're trying to get to, but still, all things had not been turned in. I think the satisfaction of the county, that can be argued. I don't know. It does in Roger's own words.
I think that I don't know how to make it.
Seems to me we keep coming back to the same thing, the conditional permit. I don't see anything different in here that's treating this any different than being a conditional permit.
Yeah, it's not under requirements of what he's really asking, it's just the fact that he issued a conditional, not this. What his authority to do.
I don't have any other discussion from me to, other than what I've said already, so I think I'm done.
You guys take as long as you need, but if someone wants to make a motion. We have really three choices here. You can reverse the decision of the zoning administrator. You can modify the decision of the zoning administrator, or you could affirm it. So reversing would be, you decide that Dolphin prevails and their conditional permit is put back in place. Modifying would be whatever you decide to do, and then affirming would be to take the zoning administrator's position. So you can move and then vote when you're ready.
What did you say, reverse, modify, what was the last one?
Affirm. Those are your three choices under the law. You can reverse the zoning administrator decision, you can modify it, or you can affirm it. Someone could call for a vote and then. But discuss, as much as you need to get to the right outcome.
I make a motion that we'll have our vote on this decision. Is that, did I miss something?
You could make a motion that there's a certain decision, so. You would make a motion to either reverse the decision, modify the decision, or affirm, and then someone would second, and then you all would vote. That's how it would go.
Well, I make a motion that we reverse or affirm.
Oh, let's.
What I'm trying to get, you gave three choices. I was trying to get that all in there so that we could make a vote out of those three choices.
That's right.
Is what I'm trying to
Well, you don't need to make a motion that you're gonna vote, you just make
Okay.
a motion about how you'd like to vote and then see where everyone else
Oh,
lies,
okay.
okay?
Okay.
I know you guys haven't done this before, trying to help, facilitate this a little bit, but he would either say, I move that we reverse, modify, or affirm the decision of the zoning administrator. And then the other, someone would second, and then you all would vote. It's just like anything else, like approving minutes, there's nothing special to it.
I move that we affirm the zoning administrator's decision here.
Okay, another motion be made. Again, or is this the motion?
No, if this dies, you can make other motions,
Okay.
so. Do. He's made a motion, if someone seconds, great, if not, then that's all, that's killed.
I'll second.
Okay, so vote. We have a motion to affirm and we have a second. So we'll just go down the line about yays or nays.
Yay.
Proceed.
Yay, based on future, based on future precedents, yay.
Ruben,
Yes.
Michael.
I just wanna abstain for now, I wanna look at some more information.
Well, this is the vote, so.
Oh, this is the vote, okay,
Yeah.
okay.
If
Then, yes, vote yes to affirm. And then, if, by the reason, right?
you can discuss your findings of fact in support of that.
Oh, okay.
So you kind of did when we're deliberating.
So we. Release, for reasons stated on the record. Rate still like, it's like a white space.
Yeah, it's on the line. Swear your name there.
You guys speak up a bit more, please.
Oh, yes, sorry. Right.
Thank you.
Okay, so
I just sort of, you have.
You can just speak up.
That we can, that would be an hour authority to change language of how, what in women's language was. We don't have that authority, we can't write that. That was not a reason, because I'm gonna be sitting here next time too, and it's not.
well, I mean.
We find that
You guys voted.
Yeah, my reasoning is that for. My reason is for a reason that. If there is a final permit to be issued, this permit. That they have right now, the conditional one is transitory, but we also have to the satisfaction of the county, they've had plenty of time to. Do their technical comments and address those. It has not been fully addressed yet, and so I think that gives the zoning administrator the right to nullify.
It says,
But technically, like, that should have never been issued in the first place, because we don't even have that number.
That's what I feel like, if
So
they down the line,
kind of-
it was wrong to begin with.
So,
And the commissioners did not keep track. They gave that all authority, but that exceeded the ordinance language. And,
so,
It will be no different than any regular, citizen come forward and need something, we're not gonna just. Give a conditional thing, they have to meet the requirements within. The ordinance and. If not, we have to raise bond.
I mean, I guess be that as it may, a conditional was still. Issued, it'd be the issues after that I have now. That was.
60 days wasn't.
Sounds like you guys are still deliberating, so we have to vote, so you're gonna have to, we don't let it go.
Okay, I'm sorry. I didn't know like we reason.
How she stated your individual reasoning, and you don't have to agree all on the same reasoning.
Okay.
You'll have to come to consensus on the reasoning, you
Okay.
deliberate, you vote,
So we need a motion to adjourn.
yes.
I'll make that motion.
I'll second that.
Okay. All in favor? Aye. Okay. Now we can still.
And then.